Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. One big takeaway for me, though, of the oral argument is that in the lead up to Moore v. Harper, there has been a lot of commentary on it, and a lot of it is focused on the idea that any use of the Constitution's elections clause to limit what state courts can do related to state election laws was kind of a fringe theory. And notably, nobody who was standing before the justices on Wednesday disputed that there is some limit on what state courts can do because of the elections clause. And here is the U.S. Solicitor General Elizabeth Prelogar making her point.
With respect to this idea of whether there's an outer federal constitutional standard that could apply here, we agree that that's so, and the court could recognize that kind of constitutional claim. Now, we also agree that that would have to be highly deferential, and I think that that stems from the recognition that to state this kind of claim under the elections clause, you would have to be identifying a situation where a state court isn't actually engaged in the process of judicial review.
Alicia, I found that fascinating, again, just given all the commentary and the run-up to this case. There are obviously disputes about how high that bar should be, whether, as the Solicitor General says, there should be so high that it only gets triggered essentially if a state court is doing something that does not look like law. But fascinating to me that everybody in this oral argument agreed that there is some sort of elections clause standard that the U.S. Supreme Court is well within its rights to review here.
Right, and I don't know where, I think that's where justices, again, were struggling to draw. What is the standard? Where's the line? In Pennsylvania and North Carolina, you have partisan judges. They're actually elected. They run under the party labels. And here it seems pretty clear to me, and again, this was the exact same election, the Pennsylvania case from a few years ago. It was very similar where they reinterpreted, or I wouldn't call it again, interpreted the state constitution under this free and fair election clause to redraw maps. They are essentially writing law here, and under the SCG's implication that there should be some kind of standard. I don't see how in this particular case, both the North Carolina and the Pennsylvania a few years ago, how that wouldn't meet such a standard in which the Supreme Court should intervene. And to that point, I think that's one of the reasons why the Supreme Court took up this case. I mean, we're seeing more and more of these cases percolate in the courts as state Supreme Courts become more partisan and become more activist. So I think they needed to address this law. In this case, as again, North Carolina's, it just seems so clear cut that the judges were usurping the position or the power of the state legislatures. And I mean, there are probably fuzzier other cases. And I think actually the New York case where the state Supreme Court struck down the maps and ordered them redrawn is a little trickier because the state constitution, which was, by the way, proposed by a legislature and then voters amended the Constitution to set up this bipartisan independent redistricting commission and barred partisan gerrymanders. I think the New York Supreme Court was right on that, and I think they actually correctly interpreted the state constitution, whereas here in the North Carolina case, they basically just made up law out of whole cloth. But again, how does the court set some kind of like limiting principle and draw the line? Whereas, again, I think maybe perhaps what New York did or the New York Supreme Court did may have been constitutional, whereas what North Carolina Supreme Court did wasn't. I don't know. And that's, again, I think that's where the justices, especially Justice Kavanaugh and Amy Coney Barrett, and even the chief were kind of wrangling with that.
But I think that's a good point because the political valence of even the strongest version of the elections clause, I think at the very least cuts both ways and maybe cuts in Democrats' favor because Kim, again, their argument is that state constitutional limits are not binding on what a state legislature can do. So remember what happened in New York. The state legislature passed a very significant gerrymander favoring Democrats. The state courts threw that out and drew their own map. There's a reasonable argument that Republicans owe their House majority, and if we end up getting Speaker Kevin McCarthy next year, that is due to these changes in New York. And so even under the strongest view of the elections clause, what happens is that New York legislature's gerrymander might have stood and we might still have Speaker Pelosi. And so, again, I think that a lot of the commentary has been disconnected with the actual facts of what's going on in this case. And even if what the critics of Moore v. Harper don't want to happen, that the strong elections clause view wins out, it's not at all clear to me that that helps the Republican Party.
Right. I mean, this is why the rhetoric was somewhat crazy. But I think it all comes back in the end to the point that Alicia was making, is that you can look at what happened in New York and you can look at what happened in North Carolina, and there are differences under the state constitution and whether or not what was happening was reasonable or not. And that may be where the Supreme Court ends up in the end. I was really struck by how often the justices all kept coming back to Bush v. Gore, which many people will remember in 2000 hanging Chads in Florida. And after a certain point, the Supreme Court stepped in. It was reluctant to do so, but it felt compelled because what it found in its ultimate decision was that the recount that had been ordered by the Florida Supreme Court was violating the Equal Protection Clause because it was treating some voters as worse than others. And there was a concurrence in that case that was written by then Chief William Rehnquist, along with Justices Scalia and Thomas. And it noted that the Supreme Court was reluctant to get involved in a state court's overseeing of these kind of procedures, but that when it engages in grossly unfair interpretation of some sort of state election statute or the state constitution, that in essence usurps the power of the state legislature, and in those cases the Supreme Court needs to come in. Kavanaugh, Amy Coney Barrett, this was appealing to them potentially, that maybe will come out of this is that state courts will retain their right to review things like this, but would need to adhere very closely to the text of their own constitutions and be given a warning that when they did not do so, the Supreme Court would step in and exert some authority. Now, I don't know exactly how that test looks, and that was certainly a subject of discussion during the oral arguments as people were debating this, like what's the limiting principle there? How do you order state courts to do that? But it seemed it was finally putting its finger on this because, as we mentioned in the opening, when the North Carolina Supreme Court did this, it did this even though there is no mention in the state constitution of partisan gerrymandering. The Constitution mentions free elections and the right to assemble and freedom of speech and equal protection, but not necessarily a power for the court to engage here. And maybe they could find it if they looked hard enough, something that would pass Supreme Court muster, but that could be where we end up in the end, a sort of requirement that the courts be much more careful in how and when they step into these situations.
Two final points here. One is that another thing you didn't hear during oral arguments at all was the name Donald Trump. There has been some suggestion in the press that if the Elections Clause advocates win in Moore v. Harper, that it would let state legislatures appoint presidential electors directly after the election, ignoring their state's popular vote. I just don't think that's correct because the Constitution also says that Congress can set the time of the presidential election, and that's Election Day. That's in federal law. And so I think if any state legislature tried to go back after the fact and appoint new electors, that it would get thrown out in federal court in a hot minute. The other point I would make is just that I do think that some of 2020 and 2024 is hanging over this argument in that state courts have gotten pretty aggressive in the ways that they are willing to rewrite these election statutes. And the one I would point to now is not North Carolina, but Pennsylvania. And in 2020, the Pennsylvania Supreme Court rewrote the deadline for mail ballots and said that mail ballots that were supposed to arrive on Tuesday, Election Day, would still be valid if they arrived on Friday. And that was eventually held up by the state Supreme Court. There were about 10,000 mail ballots that came in late. They were not counted. But you could have imagined if the presidential race between Donald Trump and Joe Biden had turned on Pennsylvania, if it was very narrow, like the 2000 Florida recount, 500 votes or something like that, that would have been real mayhem. And everything would have been decided by, what do we do with these 10,000 late ballots? Do they count? The state Supreme Court says yes. The U.S. Supreme Court says maybe, maybe not. And I think that's not a situation that we want to get ourselves in, Alicia.
Right, and put the shoe on the other foot. I think Democrats should agree on this. I mean, there are Republican majorities on some Supreme Court still, Wisconsin for one. And I believe Ohio, the Republicans still have a Supreme Court majority there. Florida, it's almost entirely Republican. And do they really want these state Supreme Courts weighing in and perhaps overturning state laws and rewriting their election laws to help Republicans, which is essentially what these Pennsylvania did and now North Carolina's Democratic Supreme Court has done. So I think both parties just have a very vested interest in seeing this case resolved to limit the powers of the state Supreme Courts and state judiciaries to overrule the legislatures.
Thank you, Alicia and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we will be back tomorrow with another edition of Potomac Watch.